May it please the court. My name is Camilo Salas, and I'll be arguing on behalf of all of the appellants, including the appellant who is represented by Mr. Joe Ward, who is incapacitated because of an operation he just had.
Wish him well.
Thank you. The real central issue in this case is whether the plaintiffs have a protectable property interest in the Montague lease to allow them to proceed with a takings claim for violation of the United States Constitution and the Louisiana Constitution. Now, no one disagrees that the government, a local government, has the power to enact zoning regulations that restrict the character of land use in their communities when those regulations bear a substantial relation to the public health, safety, morals, and general welfare. However, since 1922, the United States Supreme Court has consistently held that land use regulations that go too far affect a taking of property that must be compensated. And more recently, just in 1992, the Supreme Court, Justice Scalia, writing for the court, held that land use regulations that deny all economical, beneficial, or productive use of the land affects a categorical, per se, taking of the affected property, even where the regulation advances a legitimate state interest. That is what happened in this case. The plaintiffs own a mineral lease that allows them to excavate clay material that the federal government needs right now to build a levee system that is in progress in La Place, Louisiana. The plaintiffs tried twice to get administrative permits to allow them to excavate, but they were denied the permit and they filed this lawsuit. Shortly before trial, the district court granted a summary judgment motion dismissing the case on the following basis. The defendants argue that the term of the lease is for a period of 3 years from the date the lessee procures approval to commence operations from local, state, and federal authorities as needed. And that because the defendants had not given one of those permits, that contingency had not been met, and therefore there was no real contract in effect. They said that that requirement for permits was a suspensive condition. So this is like a catch-22, where the plaintiffs had a contract, a lease, that allows them to dig the clay, but they went to get a permit from them, they denied it, and they said, because we denied you, that meant that you never had a standing to begin with.
Mr. Salas, it doesn't seem to me if it's a catch-22, we're dating ourselves to know what that means, but
yes.
That if it's a catch-22, it's of the parties making, not of St. John the parish is making. I mean, the contract is written the way the lease is written the way the lease is written. You disagree with this interpretation. You know the language better than I do, but it does say that the lease shall be for a period of 3 years from the date. that St. John the parish and other entities would issue the relevant authorizations. So they didn't write the lease, you and the other parties did. And I may be mistaken about who wrote it, but nonetheless it wasn't the parish. Respond to this. It seems to me if every lease, according to, I don't know if it's the mineral code, and you tell me if this is right, every lease under Louisiana law has to have a term.
Yes.
And it could be a primary term and a secondary term based on production. This doesn't have a primary term until you get the authorizations. So whatever you're doing out there on the property beforehand is not because of the lease, it's because of some authorization you have from the same document. But the lease hasn't even started until the authorizations. Help me with that.
Okay, well, clearly the lease does not say anywhere that for the lease to begin, there has to be a rezoning of the property. It doesn't say that anywhere. It doesn't say it anywhere.
It doesn't say something a lot like that?
Well, what it says is, for a period of 3 years from the day lessee procures approval to commence operations. Commence operations is one thing. Dig clay from the ground is something else.
Counsel, it was zoned, the property was zoned residential, R1, at the time the parties entered into this lease. Is that?
Yes.
Okay. Does that zoning permit the operations, when you just use the word operations, does that zoning permit that kind of operation without any further action?
No, the R1 zoning only allows for the building of homes,
Residential, right.
which by other regulations are not allowed now because it's a flood zone. So basically, what they did is they said this is residential 1, but nothing has ever been built there, and nothing can be built there because it's a flood zone. So
that seems like an argument for the landowner to make, not for somebody with a mineral lease to make.
well, the leaseholders are in.
You took the rights that the landowner could give you. The lease granted the rights that the landowner could grant. And it had the terms in it that it termed. The argument that some sort of taking of not because it's unusable as residential, I don't know how a right would be created by this mineral lease based on the argument that you're making. That again, you just got the rights, or the lease just grants the rights that the landowner had.
Well, no, I mean, this court and the Federal Circuit have held in prior cases that a mineral lease creates a protectable property interest that is subject to protection by the Constitution. The issue in this case is simply that the defendants argue, that the lease had not started because it could only start upon receiving approval to commence operations. But what happened, there was no approvals because they admit that there were no need to obtain approvals from local and state authorities to commence operations. And the plaintiffs...
With the answer you just gave Judge Engelhardt, that zoned R1, you couldn't conduct the kind of operations this is talking about. You may be talking about two different things, and I just want you to clarify. You stated that as long as this was zoned R1, the kinds of operations this lease is talking about could not be conducted. But now you're saying something that you probably mean differently, and I just want you to help me understand what's different about it.
Okay, so the lease period has two components. One is the primary term, and the second term. The primary term is for 3 years, and that's standard in this type of leases in Louisiana. And basically what it does is the lessee pays a fee to the landowner, and during those 3 years, the lessee may do nothing, just sit on it. But at the end of 3 years, the lease ends. On the other hand, if the lessee during that 3-year period starts production, then the lease will go automatically into the second term, and that will go ad infinitum as long as there is production of minerals.
So if, Mr. Salas, you're talking about what's standard. I'm sorry, Judge Wilson, I don't know who should go first. It seems to me this lease could have been written that we'll grant the right to you for 3 years to do whatever is necessary to commence operations.
Right.
To get the authorizations and whatever. So starting on the date of the execution of this lease, you have 3 years to do whatever is necessary and start your production. But the lease wasn't written that way. At least is what the district judge said, and your friends on the other side insist it's true. They wrote a lease that says you have rights to pursue getting authorization to commence operations, and the lease starts once you get that authorization. That's a much different, it seems to me, kind of lease. So I don't know what's standard in Louisiana, and you may be saying this is the way they're written, but there certainly seems to be a pretty good argument there's a difference between those two kinds of leases. And your term doesn't start, which may mean the lease doesn't start, until you get the needed authorizations to move this from R1 to whatever the zoning would be for what you want.
Until we get the authorizations to commence operations. Now, the word commence operation is not defined in the lease. And what we interpreted commence operations were to do the first things that must be done in such situation, which is do the exploration for the clay. And that they did right away. And on top of that, they obtained a series of studies, environmental studies, that must be done before any exploration, any removal of clay can be taken. So they spent a couple of years, 3 years, doing all of that stuff. It was not until towards the end of those 3 years that they needed to get the permits for clay. So the permits for clay removal were not requirements to commence operations. The permits for clay removal were just that, were permits to remove clay, which by doing it would have triggered the commencement of the second period of the lease. So
I guess what I was going to ask earlier is if the 3-year term never comes into play, so you said earlier that under Louisiana law, a lease has to have a term. Is there a term separate from this 3-year term?
No. What we're saying is like the 3-year term did come into effect, and it started when we started doing exploration, which was the beginning of it. We procure approval to commence operations.
You're saying that operations commenced immediately, the 3-year term was
Yes.
therefore in effect?
Yes.
You did all these things, and that
Yes.
was enough to commence operations under
Yes, you cannot dig clay unless you first explore and find it, because it has to have certain qualities for this purpose.
Would the plaintiffs have entered a lease just to explore for clay?
Well, I don't think so, except that in this case, the clay had to be of certain qualifications that are required by the Corps of Engineers for that particular purpose of building a levee, because a certain type of clay can withstand the water and the things that happen with levees. So the lessee had to procure approval to commence operations. They wrote to the federal government to obtain a permit to commence operations, and the federal government wrote back and said, you don't need a permit to commence operations. And with respect to a state and local permits. The defendants have admitted that there were no permits required. So the plaintiffs engaged themselves in the exploration for clay, which is the first thing that needed to happen. And at no time did the local authorities, the federal authorities, or anybody come in and say, hey, you drilling holes there, you exploring for clay, you shouldn't be doing that, or we're going to stop you, or anything like that. That went on for a couple of years. And on top of that, the number of environmental studies that take so long to do before digging clay of such magnitude can be done. As I'm sure you know, the federal government requires all kinds of NEPA and all those studies that need to be done, and that they did. So the bottom line is that changing the designation of the land was not something that needed to be done to commence operations.
Mr. Salas, your time is up. You could pick up on this on rebuttal.
Thank you.
Good morning, Your Honors. My name's Carl Butler, the Butler Law Firm. I'm here with my associate, Kristen Baroni. We represent the appellees in this matter, St. John the Baptist Parish and its governing authority, St. John the Baptist Parish Council. After listening to Mr. Salas talk about the arguments in support of this lease, I'm reminded of a song that Dolly Parton released back in 1999.
Are you going to sing it for us?
I'm not going to sing it, but there's a couple of lyrics I think are applicable here. The song was The Grass is Blue. And it was a song about a bad and painful breakup between two love interests. And Dolly was saying that she didn't know how she was going to survive because the experience had been so painful. And the only way she could think of to survive was to pretend like it never happened and to pretend that the opposite was really true. And there's one verse in that song that says, there's snow in the tropics, there's ice on the sun. It's hot in the Arctic, and crying is fun. And I'm happy now, and I'm glad we're through, and the sky is green, and the grass is blue. Mr. Salas and the appellants want the panel to conclude that the grass is blue. It's not. In other words, let's just pretend like this lease never happened. Let's pretend that the primary term of the lease was meant to be effective on the day it was made. Let's pretend that the words of the lease don't really mean what they say. Let's pretend the lease is perfectly fine and the parties did all they were required to do.
Well, explain for me, under Louisiana law, in your view, what is the period of time properly considered to be between the date of execution and the date that the primary term begins, when authorizations are obtained, which is what you say, and of course Mr. Salas says otherwise. But let's say we agree with you. The lease doesn't commence, and district court agree as well, until those authorizations are obtained. What is that interregnum period called? Is it under the lease?
I don't think it's called anything in this instance because there's no effective date.
Is there no lease? Is the lease even in existence yet?
In the abstract, perhaps, there's a document that says it's a lease.
Aren't there some rights, though, given to the, lessee may be the terminology of the document, but whoever the grantee is of this document, some rights, which is to go out and see the quality of the clay, I suppose. I think under common law, maybe as opposed to civil law, we don't use French so much, might be something like a license to do that. Do you have any sense I mean, it certainly makes sense that this was a lease. I don't know if is it entitled a lease? I guess it is. Yes, solid mineral lease. And so everything under it is lease language. So it's a very odd duck. Are you familiar with these kinds of solid mineral leases? Is this the way they traditionally look in Louisiana?
None of the cases that we've looked at indicate a lease like this had ever been entered into. This is a lease whose primary term says what it says, the primary term provision. If the parties had intended this lease to be in effect, they could have said the lease term or the primary term of the lease is in effect upon execution. They could have said that the primary term of the lease is effective upon the date first above written, because there was a date at the top of the lease.
I mean, it's dated, and nothing in the lease says it's not immediately in effect, right?
And the corollary is that nothing says that it is in effect. I think we'd have to look at the conduct of the parties to make some determinations.
Well, they go on the site, they explore, they do some things. I mean, you know.
Pursuant to a separate agreement, which I think is interesting, because the Musser case, the Musser land case, which is a case from this court, talks about a lessee's right to enter upon the property of the landholder, the lessor, to conduct seismic operations, which is presumably part of exploration activity. And in that case, the court concluded that that's an implied right that the lessee would have once a valid lease is entered into. What happened here was the parties acted as if they didn't have a valid lease. When Dr. Montague found out that the lessees or the alleged lessees were on his property conducting these studies and surveying and performing core samples of soil, he said, wait a minute, what are you doing? You don't have a right to do that. I never agreed to that. And besides, if you're going to do that, you're going to have to pay me. So there's a letter from Mr. Ward, the other counsel for the appellants, where he says to Dr. Montague, okay, well, this letter will confirm that we now have an agreement, that we have these core samples, we've done this work on your property, we'll share that data with you, and we'll also agree to pay you $50,000 somewhere in the future once we start selling clay in quantities. That's a separate agreement. If they thought they had a valid lease and that they had a right to do these things, why would they enter into a separate agreement?
Well, Mr. Butler, isn't another way to look at this, that this lease is immediately effective and it grants some sort of rights. It's not completely just a concept. There's been an agreement, and the lease begins. A term begins, a definite set term begins upon, as you say, and lasts for 3 years after the authorizations are obtained. Is there such a thing in Louisiana as an applied reasonable term? It seems to me that the whole premise for this lease is, and you interpret everything in contracts reasonably, I suppose, even in Louisiana, that you have a reasonable period of time to get those authorizations, and that is the implied term until you then have a definite 3-year term.
Well, in this instance, what would the implied term be? Take the primary
Reasonable
term.
period of time to get those authorizations.
Well, the parties obviously knew that time would be needed, which is why they suspended the commencement of the primary term. This was a project that was allocated for funding by the Congress in February 2018. The groundbreaking was July 2021. This lease was made back in October 2018. The parties obviously knew that they were going to need some time to ramp up to get ready to sell this clay to the Corps if they could get on the approved list. They anticipated time. How much time they thought they would need, we don't know. They also anticipated they were going to need some kind of government approvals. This was a $1 billion project. So a lot of hoops and loops to have to go through local, state, and federal level to put themselves in a position to be able to sell this clay if they could get it out of the ground.
And they travel under the force majeure clause?
Travel meaning?
I mean, does that somehow save them? It says that when excavation, reworking, production, or other operations are delayed or interrupted by force majeure, that is, and skipping on down, as a result of some law, order, rule, regulation, requisition, or necessity of government, federal, or state. In other words, inability to get the approval somehow still travel under the lease, even though the term never comes into effect?
I don't see how force majeure becomes relevant here. I mean, this was
I don't know that they're making that argument, but I just ask because it's sitting there at paragraph 10 of the lease.
the landholder here, the lessor, alleged lessor, was a local public official, an elected official, who tried on 2 occasions to get the rezoning of the property, which was the first step that needed to be obtained. The first approval was he needed the property to be rezoned from residential to rural to allow these permitted uses. It didn't happen. Now, perhaps they could, and they only had to wait a year to come back and reapply. So if they got denied in July,
Well, they tried twice.
they tried twice, and they could still try again now. I mean, they're beyond another year, so they could have come back and continued to try. Or, here's what they could have also done. They could have gone back and retooled their lease and tried again under a new lease. Again, they were in control of this, not the parish, and I think Judge Southwick made that point clear earlier. This is a dilemma of their own making. And now they want us to pretend like it didn't happen the way the lease reads and what the lease says happened. It happened the way it happened. These were sophisticated negotiations. Dr. Montague is a local medical doctor. His family owns lots of property in St. John Parish. These gentlemen who came in from wherever they came from were sophisticated businessmen. This was a sophisticated transaction. They made this deal. And now they want to turn this deal on its head and blame the parish because it didn't get off the ground. Again, they want to pretend the sky is green and the grass is blue, and it's not. It is what it is. The lease says what it says.
Well, we got to stay away from the merits of the claim, I guess. We're talking about standing at this point.
Correct.
And the question of understanding is, do they have an interest in this lease? So the district court says it's a suspensive condition, the term never comes into play, therefore there's no lease.
Correct.
They say, well, we had all these operations, it commences. The parties say, the parties to the lease say, we intended it to be in effect, we consider it in effect. I think Dr. Montague has sworn to that, right?
He said a couple things, and he also made some legal conclusions.
I guess back to Judge Southwick's point, though, how do we treat this interregnum period before the operations commence, excavation, whatever that may be, or are the operations inclusive of the exploration activities and things that happened?
Again, I think they operated under a separate agreement. I don't think they were operating under this lease. I don't think Dr. Montague thought he had, and of course when he did the affidavit he said what he said, but prior to that, I don't think Dr. Montague believed that they had any rights to do anything on his property without getting him to agree separately to do that and agreeing on separate consideration and compensation for doing those things.
That was under the terms of this document.
It didn't reference that. It didn't reference the document. The agreement that Mr. Ward confirmed in his letter to Dr. Montague didn't even reference the lease. It didn't say pursuant to...
the lease referenced the additional payment or whatever. Am I wrong?
Well, it did. It said that you can do these things if you come to me and get consent and agree to pay me, but that's separate from this agreement, from this lease.
So without that agreement then, where we were, I guess, and you're telling, is you got to get the zoning changed.
Correct.
And other federal whatever approvals are required, but the zoning change everybody knows about. You got to get that, and until you get that, nothing.
Nothing. No operations to excavate, to mine, and to produce the clay, which is ultimately what this endeavor was all about. Judge Southwick asked Mr. Salas, well, could you just have had a lease to explore? Well, that wasn't what they intended. They weren't just trying to get the right to explore. They were getting the rights to enter upon the land to ultimately produce clay to sell to the Corps to make money. So this wasn't about a limited term agreement to just enter upon the land and make some exploration and do some core sampling and surveys and that kind of thing. They wanted ultimately to sell clay deposits from the ground.
They need a legally cognizable interest that has been injured by the refusal of St. John the Baptist Parish to rezone. Your argument is that this lease primary term had not yet commenced. It seems to me the broader question is, do they have any rights under this document that's entitled to the lease, but may be doing other things? And it does seem to me that's authorizing them to go out there at the schedule and at the price and at the location that they agree to with the lessor, which is set out in this document. I'm avoiding calling it a lease. Those are some rights that are futile or useless unless this property is rezoned. Isn't that an injury?
I would agree that potentially is an injury, but only if they can show the parish took some action. It was some state action, some government action that interfered with those rights. They did what they did on the property without any interference from the parish.
Yeah,
There was no
like
interference.
it's futile or worthless. That the rights they were given have been undermined by the parish's refusal to rezone, which is getting into the merits, which they, if they ever got to that stage, the parish may be completely defensible in their refusal to rezone. But I'm just talking about, do they have an injury to a cognizable right granted by this document that is part lease at least, and perhaps something else as well?
I certainly understand the question, Judge, but the rights that they exercise under this document, whatever those rights were, they freely exercised those rights. They conducted their operations, whatever you want to call those operations. They conducted their seismic studies. They did their core sampling. They did their surveys. They did their environmental surveys. They did everything they wanted to do. The thing they couldn't do was get the property rezoned. That's a separate operation. So yes, they did commence some operations. Those operations were allowed to be conducted. The parish had no interference. There was no government action that interfered with those rights. The ultimate right was to conduct mining operations, clay mining operations, and for that they needed rezoning. For that they also needed a conditional use permit, which they were not able to obtain. So again, it raises some questions here as to what their real intent was here. Again, let's assume they had gotten the permits or the rezoning. What date was that supposed to be? Was it going to be one date or multiple dates? Because we have two separate sets of approvals that were needed here. There was an approval for the rezoning, and then there would have been an approval for the conditional use permit. So was the primary term going to start upon the first approval being granted or upon the last date of the last approval? Because there were other approvals, so it's just not one approval. So it's reading this lease, it's hard to understand just what date in the future was going to trigger the commencement of this primary term.
What's the effect of that ambiguity on your case?
I think the effect of it, since we can't really determine the true intent of the parties, is that it should be interpreted against the drafter, which again, as the court pointed out, it wasn't the parish that drafted this. So when the true intent of the parties can't be determined from this ambiguous language, they shouldn't be able to walk in and get the benefit of their own ambiguity that they created in their own document.
All right, Counsel.
Thank you.
Just a couple of things here. The lease itself does state at paragraph 1, lessor, in consideration set forth below in paragraph 4, hereby grants, leases, and lets unto the lessee the exclusive right to enter upon and use the land hereinafter described for the exploration, for production of, and sale to third purchases. So the document itself did give some rights to the plaintiffs. It's stated right there in paragraph number 1. It was not contingency. Excuse me. A portion was contingent, and that is the start of the first clause, the primary clause. But that was not a suspensive condition, which is something different under Louisiana law. A contract can be contingent on something, but that does not mean that it is suspensive. Suspensive means that it cannot be enforced, and therefore it has no validity. And they are arguing that the lease was a suspensive condition. It was not. But even if it was, and even if obtaining the rezoning was a suspensive condition of the lease, the fulfillment of that condition was frustrated by the defendants when they illegally denied the rezoning, and pursuant to Civil Code Article 1772, the condition is regarded as fulfilled. And that is Louisiana law, and it's very clear. Now,
Let me ask you, Mr. Salas, under your view of this document, what was day one of the 3 years? Was it the day the document was signed, or was it some other time?
well, day one for
The 3-year term that,
for the 3 years, it was day one. We interpret day one, which was the date, I have it, the date that we went there to start when we commenced operations.
right, thank you.
And that was
I don't care the actual date, just want to know generically what.
February 28. And then during that time, we did 16 borings, which were drilling into the land to find the right type of clay that the Corps of Engineers needed. And that's what we consider to be day one when we commence operations.
Well, when you buy a lot to build a house, generally speaking, those contracts have some sort of provision in them to say, well, you can go and inspect the property, you can do soil borings, you can do geotechnical, up to the buyer, and you have a certain time period to do that. I don't know that gives the buyer any rights to the property at that point, other than the limited rights to sort of determine whether they're going to move forward to closing.
Well,
So are these kinds of activities similar to that?
Well, yeah, this is a little different, Judge, because what the council was talking about, the payment that was later agreed upon with Dr. Montague, that was on the paragraph 7. So if, on the paragraph 7, if the lessee wants to do something beyond on the property, he has to pay compensation to the lessor to do that work. And so we agreed that we went in there without reaching out to Dr. Montague, and we did the work, the commencement work. And Dr. Montague came and said, hey, you go in there, you owe me money pursuant to paragraph 7. And we said, yes, we do. And they agreed how much was paid. That points that the lease was an enforceable agreement. Dr. Montague enforced paragraph 7 against us. It was not a suspensive condition, because if it had been a suspensive condition, the entire agreement would have been null and void. It had been unenforceable, which is what they're saying it is. It is unenforceable. It didn't exist. But yet Dr. Montague enforced it against us, and we paid him. The other point here is something that Judge Wilson brought about standing, and I meant to mention this, something in my direct. The the district court found that there was a lack of standing. And you know, the lack of standing is standing under constitutional standing, and that implicates the jurisdiction of the court. And basically, when there's lack of standing, the court may not enter a judgment that determines the merits of the dispute. So even if we were to lose, the judgment should have been without prejudice because of the lack of standing.
All right, counsel, thank you. Thank you both for helping us understand this case. We'll take it under advisement. And we are in recess until 9 a.m. tomorrow.
Thank you, Your Honors.